the rule of completeness would not cover the admission of the entire tape. So I gather this is not the next thing on the agenda, the playing of that recording?
No, sir.
So why don't you make a list before noon, or by one, I should say, before we start this afternoon, of those portions you wish to admit, unless you want to tell me now that it's the 1 to 149?
I'm willing to, actually, up to, I indicated that as a matter of, to resolve this, I indicated that I'm willing to go up to page 140, line 15.
All right, then let me ask you, Mr. Albee, when we start this afternoon, to give me a list of those other portions you believe should be received, and don't say the whole thing, because I already looked at it. I mean, you've already said that for the record, so that's in the record, but if you want to highlight those that you believe ought to be received either into completeness or something else, and then also be able to reference those sections in the portion, in the first 140 pages, which justify that.
My proposal was in the contemplation of a stipulation that that's all that's going to be played. If that's not the stipulation, then my preference would be what I'd said earlier.
All right, well, give him the list. Don't read it to me. I don't want to.
Okay.
He's good.
Give him the list.
It hasn't changed.
No, it's, well, here, this is what it is. Just make sure that there's no...
So you...
So either that's what I'm asking for, or as a matter of stipulation on the 140, line 15, which is more likely to get in otherwise.
So you take a look at that list and then point out those sections you believe ought to be received under the rule of completeness or for some other reason, and then and be able to say why. Well, and then we'll take it up.
He's got to decide whether he's going to accept the stipulation. If he accepts the stipulation, then we're just going to play up to page 140.
I understand. That's understood. Okay, so we can drop that now. And are you back? Again?
Bad penny?
I got bad penny, yeah. All right. Let's continue with Dr. Mainland then, huh?
Yes.
Ready to go?
Yes.
Ask the jurors come in, please.
Please be seated.
Good morning, everyone. And we'll continue with the examination of Dr. Mainland and Mr. Albee.
Thank you, Judge. Dr. Mainland, one thing we covered yesterday was the note that was provided by David Jensen to his teacher on December 2nd. Do you recall that?
Yes.
And you had some questions about whether she wrote the note.
Yes, I did.
Were you aware of Ms. DeFazio's testimony at the forfeiture hearing on August 29th, 2000? Actually, I think it was August 30th, 2007. At page 3, beginning at line 8, question, Ms. DeFazio, you indicated that on December 2nd, David Jensen gave you a note. Correct. Answer, yes. Question, and that note was signed by his mother, Julie Jensen. Answer, as I recall, yes. Question, and did you recognize the handwriting as being Julie Jensen's? Answer, yes. Question, and how were you in a position to identify handwriting? I'm just curious. Answer, well, she would write notes in their assignment pads.
If that's what she said, that's what she said. I'm not going to argue with it.
Well, is there some reason to dispute that she wrote the note, given that testimony?
The testimony, I guess, would make me lean a bit the other way, but I'm not 100% convinced.
You have no evidence to the contrary, right?
I personally, no, have none.
And at pages 4 and 5 in that same testimony, she was asked, beginning line 25, page 4, Did her handwriting look normal to you? Answer, yes. Question, she was coherent in the note, correct? Answer, yes.
Objection, Your Honor. Again, under the doctrine of completeness, I would request the counsel now read back Teresa DeFazio's testimony from this hearing as to what she said about this note.
Give me the date.
I'd be happy to read it if Mr. Jamboys had the transcript.
Well, I don't have it, but I do know that Teresa DeFazio made specific statements about that note during the course of her testimony. And I don't want to, because of speaking objections, I don't want to go into it as to what it exactly is. But I know that it was not consistent with that testimony.
Well, you're not allowed to testify. Why don't you go take a look at what he's got there if you don't have a copy yourself?
Well, he doesn't have a copy of the testimony of Teresa DeFazio from this hearing either. But he's talking to this witness about Teresa DeFazio's testimony from the hearing.
Judge, what it is I've read Teresa DeFazio's under oath testimony at a prior hearing in which she said she identified the handwriting.
Was this the hearing in July?
Yeah, August.
What's the date of the testimony?
August 30th is this transcript.
And you say you're reading from your notes rather than the transcript?
No, I'm reading from the transcript from August 30th.
What am I not understanding? I thought you...
Mr. Jamboys, wait a second, hold on, Judge.
Just a minute. Just a minute. The question is, if he's reading from a transcript, and don't you have the same transcript?
That's not the point that I was making. The point that I was making, Your Honor, is that in addition to testifying at the previous hearing, Mrs. DeFazio testified in this trial in front of this jury.
Okay.
And she testified about
You
that
can
note.
still... No. He's still entitled. The objection is overruled. Go ahead.
In terms of the arm testimony you were giving about the position of Julie Jensen's arm, you're unable to say that she was in that position before being moved by the paramedics, correct?
If I'm correct, if my recollection is correct, they found her in that position or one very similar, and all they did was move her slightly to apply the EKG lead pads and left her.
Where does that information come from?
Might have been the police report, it might have been the first responders, I can't remember.
You know, so you're not aware of Mr. Wilkinson's testimony where he indicated that he may have rolled her over and rolled her back?
No, I'm not aware of that.
You have no personal knowledge as to whether she was in the same position in that photograph as she was when the paramedics found her, true?
I can't really answer that because I know what paramedics do frequently, and I know they frequently put the body back in the position in which it was found. So can I say 100% that that's what they did here? No, but I believe it.
Well, why is it that when we come to what a pathologist should do, like note injuries to the nose, and those aren't noted, you tend to think, you express doubt as to whether that was really the case. And then when we have other things like paramedics and what you think they usually do, and we have contrary testimony, then you're also tend to doubt that each time, favoring some theory.
Objection, that's a compound argumentative question.
No rule.
Well, I looked at the placement of the EKG leads on the body, and there isn't one. There's one on the right side of the chest, on the lower portion. There's not one on the left side. That would be consistent with them just moving her far enough to get the three on and decide that she's deceased. That's what I believe. I mean, I can't give you any more hard evidence than that, but that's what I believe.
Why wouldn't you believe, for example, that Mr. Chambliss would note, Dr. Chambliss would note an injury to the nose if there was such injury?
Like I said yesterday, it may have gone back into place by the time he did the autopsy.
He didn't even note any abrasions in that nose, right?
No.
And Mr. Wilkinson testified that he may have rolled her over and rolled her back.
I haven't seen the testimony, but if that's what you say he says,
So we have things like the handwriting that Teresa DeFazio said in prior testimony she recognized, but you doubt that. You have doubts about that?
yes, I do.
Basically, you have doubts about anything that might favor the defense, no matter what the source of information it comes from.
No, that's not true.
Even if it comes from Dr. Chambliss in his autopsy report.
That's not true.
You mentioned yesterday that you tried putting yourself in a similar position as Julie Jensen appears in that photograph.
Yes,
You said it seemed a little uncomfortable to you.
yes.
And is that because your elbow is digging in your side?
And because my arm was twisted around,
But is the elbow one of the problems as well?
possibly.
Then why would you expect to see some sort of mark lower in the ribs where the elbow would be?
Perhaps the elbow was over the soft tissue of the upper abdomen.
But the elbow would put more pressure on likely than the arm, right?
Possibly.
And there is no injury in that area where the elbow would be, correct?
I'm not 100% sure exactly where her elbow would be located. I'm not the same size as Julie Jensen. I don't know how long her arms were, so I can't really say that much more about it.
Is there any injury in the lower rib cage or abdomen?
Not that was noted in the autopsy and not that I could discern from the photographs.
You're aware that the defense had some blood samples tested for ethylene glycol and glycolic acid.
Yes,
Glycolic acid is one of the metabolites of ethylene glycol.
it is.
That's one of the substances that the body converts ethylene glycol into.
Yes,
And the level of glycolic acid in the body would be a better indicator of what the person's medical situation is as a result of the ethylene glycol than the amount of ethylene glycol in the blood. Would that be fair to say?
yeah, if you're just looking at those two numbers, I would agree with that.
And let me show you Defendant's Exhibit 221. Doctor, and is that the testing you received from the University of Kentucky Hospital for ethylene glycol and glycolic acid?
Sure looks like it. Let me just compare. Yes,
If you have yours, I'll take mine, and I'll ask you a couple questions. And the level of glycolic acid, well, one of the tests is what, the heart blood, and one is what's called peripheral blood.
yes.
And what would peripheral blood mean?
Something drawn from an extremity or a vein that feeds back from extremity. So it wouldn't be from the heart, it wouldn't be from the vena cava. Commonly, well, I know I sampled the iliac vein. Pathologists sample the iliac vein, the femoral vein, or sometimes even the subclavian vein.
Okay. And the glycolic acid level in the heart blood was 7.1 mmol. What is that, millimoles?
Millimoles.
And the peripheral blood was 7.2 millimoles per liter, I guess it is, right?
Yes.
Both of those are in per liter amounts.
Yes.
And according to the testing laboratory, the University of Kentucky, if the value is greater than 8.5 millimoles per liter, that's associated with a high probability of acute renal failure.
Yes.
And she was not that high, correct?
No, she was not that high.
So based on that glycolic acid level, there may not have been a high probability of renal failure in this particular case, true?
I don't think I would agree with that,
And what's that based on, doctor?
because I know she's got some glycol, or some metabolized ethylene glycol in her blood and in her liver that is going to be converted to glycolic acid yet. And so, for all I know, that level could rise
Well,
had she lived.
in terms of
Could have rised.
the,
I didn't say had she lived what?
Had she lived, that level could have rised,
well,
or
there's,
risen. Sorry. Hope there's no teachers on the jury.
is there, the amount in the blood is very small. There's virtually none to be converted to glycolic acid, fair to say?
There's enough.
Well, how much glycolic acid did that produce?
I don't know, but it'll produce some. And there's also some in the liver, and there's also some in the brain.
If that was the peak amount in the blood, Dr. Mainland, 55 micrograms, that wouldn't even cause an emergency room department to treat the person for ethylene glycol.
It depends.
Yes, it is a question.
It depends on what emergency room you're talking about. Some advocate treating ethylene glycol poisoning at any level.
But the only measure we have of glycolic acid is below the amount considered to raise a high probability of renal failure, true?
Considered by this particular lab, and that's not the whole story.
Well, Dr. Porter from the University of Kentucky is one of the leading researchers on the issue of glycolic acid. Isn't that true?
I wouldn't know.
Let me show you Defendant's Exhibit 15. You recognize that as electrolyte levels. Are those all electrolytes? Electrolyte levels from St. Catherine's Hospital, the vitreous fluid taken from Julie Jensen.
Yes.
Do you also have that in your file?
Yes, I do.
If you could find that, thank you.
Can I see that, counsel? Yeah. I know I've seen it before, I just want to.
I've got it.
And these electrolyte levels are something that a physician can look at to try to determine how well the body's functioning, essentially, correct?
Yes.
Creatinine would be an important thing to look at, true?
Yes.
Nobody bothered to get a creatinine level in this case, is that right?
There's no creatinine reported, and I believe I know the reason why.
Well, and why is there no creatinine reported?
It becomes less reliable when the potassium is elevated.
Well, you take the vitreous fluid, right?
Yes.
That's what they did. And then they tested it for, in this case, sodium potassium chloride, BUN, which is what?
In the vitreous, it would be UN, urea nitrogen.
And for carbon dioxide.
Yes.
And the lab would decide to test for these things before finding out the results for the others, right?
For what others?
Like creatinine.
I'm not sure. I'm not sure how they did the test.
Well, doesn't that make sense? You decide before you begin any test what test you should perform, correct?
I think they do the test and decide what should be reported. But that was St. Catherine's Hospital in 1998, so.
You have no evidence that there's any testing for creatinine, right?
All I know is what's on the paper, because I wasn't at St. Catherine's Hospital in 1998 when these electrolytes were tested.
Is your answer yes?
I have no evidence. I can't answer that yes or no again, because I believe that this is done as a panel, and if something is not considered a reliable result, it's not reported. So, I mean, if I take that part of it away, my answer is yes.
Did you talk to somebody to see if they did creatinine?
No.
Your personal notes reflect some concern that no creatinine was taken, right?
It wasn't concern, it was an observation.
Because that's an important level, right?
In ethylene glycol poisoning, it is.
And the BUN levels here are only slightly elevated, would that be fair to say?
Yes.
Suggesting that the kidney is not in failure?
I don't know that I can go that far.
And what about the bicarbonate levels? Do you know what those were?
Yes,
And those were within normal limits, right?
yes.
And typically with ethylene glycol poisoning, you'd see what would be elevated or there'd be a deficiency in bicarbonate levels.
There ought to be a deficiency, but again, we're talking about blood. There's not been a whole lot of work on vitreous and ethylene glycol poisoning. And in fact, I've seen a number of ethylene glycol poisoning cases where the vitreous electrolytes, including the creatinine, were normal.
That would be the treatment, at least before, what was it? I can't pronounce that word. Fomepizole, what is that?
Fomepizole, formethylpyrazole.
That's what's used now as sort of an antidote.
Yes,
But oftentimes what hospitals would do is try to elevate the bicarbonate level, right?
yes,
Because it was viewed as one of the symptoms of severe ethylene glycol poisoning would be a deficiency in the bicarbonate level, correct?
yes.
And we don't have that here,
We don't have it here.
which suggests that maybe her level of poisoning isn't as severe as you've painted it out to be.
I disagree.
You recognize that those levels, such as the UN, the bicarbonate level, those are things that are examined in determining how severe the ethylene glycol poisoning is, correct?
Yes, the urea nitrogen and the bicarbonate in the blood are examined at hospitals to determine this, or as one factor in determining the severity of the poisoning.
And that's a factor you're choosing not to consider here simply because it's vitreous and there's less research on the issue.
I'm absolutely considering it because, as I've told you, I've seen several cases without hospital intervention where the person was unequivocally dead from ethylene glycol poison and the vitreous electrolytes were normal.
Okay. And it's fair to say that when you examine the literature regarding the metabolism of ethylene glycol, there are cases in which the person might be considered an outlier. True?
True.
Is outlier a term that you would expect any pathologist to know?
Yes.
And what it means to be an outlier is that somebody is outside what has been considered the normal range, correct?
Yes.
When you're giving us ranges like 0 to 12 hours for the first phase, 12 to 24 hours for the second phase, 24 to 72 hours for the third phase, we might have outliers that don't fall within those parameters, for example, correct?
Yes, I think I even testified to that on direct examination.
Okay, well, I'm going to take the opportunity to clarify it anyway, okay? And you also have things like a half-life. You gave a range of 3 to 5 hours, correct?
Yes.
But you understand there have been cases observed in which it's much longer than 5 hours, correct?
Cases where the patient has been put on dialysis, yes.
Even in cases without dialysis, there have been instances where it's greater than 5 hours, true?
I can't remember any of those cases off the top of my head. I don't know that I've seen any.
Are you saying they don't exist, Dr. Mainland?
No, I'm saying I haven't seen any. Or I don't recall having seen any, make that clear.
The third phase that begins 24 to 72 hours, that's without medical intervention,
Correct.
and that's different than your testimony on Friday, correct?
What did I say on Friday?
On Friday, on Friday, you said that you thought that might only be with medical intervention.
I think there had to be more context to it than that.
Well, because some people do not demonstrate the third phase until as late as 72 hours, it'd be reasonable to believe that Julie Jensen would live 38 hours past her single ingestion, correct?
No, I don't think she would have.
Well, the fact that some people do not develop the third stage until 72 hours after ingestion suggests that people can live that long after an ingestion in which someone goes through all three phases, right?
It would suggest it, but it would have to be a rather small ingestion.
Well, if the ingestion's too small, you're never going to see the third phase, potentially, right?
Yeah, now we're getting into nitpicking again, but it's possible.
Well, what's nitpicking? What's small? What's large? You tell me how much you have to drink to get into the third phase, Dr. Mainland.
I guess objection, Your Honor, it's an irrelevant hypothetical, and she'd have to drink. The question is how much would Julie Jensen have to drink to get into the third stage?
Rephrase your question.
Dr. Mainland, how much would a 110-pound person have to drink to get in the third phase?
Less than a few tablespoons.
And what research tells you that?
Numerous references on the metabolism of ethylene glycol.
Please give me one.
There's the, I knew I brought this stuff for a reason. Do you want me to haul it out, or?
If you could just tell me the name of the source.
One of the most common ones is, I believe it says in Ellenhorn, that from anywhere from a milliliter per kilogram can be fatal. And I've seen that in other sources too.
Well, that can be fatal. What I'm asking is what can be the most to be the, put you in the, or how much can you have to put you in the third phase if you're 110 pounds?
Wait a minute, that's not, how much can you have that will put you?
What is the minimum you need to have to put you in the third phase?
I don't think there's a minimum that I can broadly apply like that, but I know that studies have been done in which people ingested from 1 to 3 swallows of ethylene glycol, and this included adults and children, and from 1 to 3 swallows produce renal symptoms or third phase symptoms in some of the people.
But not all.
Correct.
With 3 swallows, it wouldn't necessarily put you in the third phase.
I don't know which of the percentage of people in the third, I don't know how many swallows each of those persons. It wasn't divided up into phases versus swallows, is what I'm trying to say.
And how much was in a swallow?
Well, for me, it's a little less than an ounce. I tested it.
But you don't know what the average, I mean, that's a anecdotal history of 1. Do we have some medical research that says how much is a swallow?
I think that was a scientific experiment. I repeated it and got similar results.
With yourself?
Yes.
Is that the sample size you typically see in the research?
No, of course not.
The people have had, you said about an ounce, so people have had potentially 3 ounces and they live, correct?
Yes.
And they don't necessarily go into the third phase, correct?
Possibly.
And the problem is you don't know how much, one problem is you don't know how much Julie Jensen drank, correct?
to the milliliter or to, no, I don't. I can only, I guess, surmise based on the evidence in the case.
Well, I mean, how many cases are there in the literature in which somebody had basically exactly 100 milliliters, and then they were followed through the whole course of how it affected them?
I couldn't answer that.
Are you aware of any?
I can't think of any off the top of my head.
So without a single past example to use as a template, isn't it difficult to determine, for example, how 100 milliliters would have affected Julie Jensen in particular?
I don't think so.
How about 75 milliliters? What would be the difference between her drinking 75 milliliters and 100 milliliters, Dr. Mainland?
I think in her case, both of those amounts could potentially be fatal.
You understand that they could be, but not necessarily, right?
They could be.
And 150 milliliters might not be fatal, true?
I believe in her case it would.
But you don't know how she metabolizes ethylene glycol in particular, correct?
I have no evidence to suggest that she metabolizes it any differently than any other person.
Well, as we've previously established, Dr. Mainland, not all humans metabolize things exactly the same way. There are variations, correct?
Yes.
We know that from alcohol, that there are significant variations from person to person in how they would metabolize and eliminate alcohol, correct?
That's, it's true, but there's more to it.
Well, the elimination rate can range all the way from, what, 0.006 to 0.04 per hour, for instance, with alcohol. We've seen those kind of ranges in the studies.
Yes, and in alcohol, the elimination rate is quite a bit faster with chronic alcoholics, for example. I don't think that you can compare alcohol to ethylene glycol in that instance because most people don't drink ethylene glycol as a recreational beverage. And we don't have chronic ethylene glycol addicts, and so we can't look at how, we don't have, we can't compare the two here in that regard, I don't think.
Well, the problem is we don't have any way to compare it because we don't have a sufficient enough sample size to figure out how people, what the variations there are in eliminating ethylene glycol. True?
No, I don't think that's fair to say.
In many of the cases of ethylene glycol, the reason that they're reported is that the person has gone to the hospital at some point, correct?
Correct.
Oftentimes those cases involve consumptions of very large amounts, like a half liter or more of ethylene glycol. True?
Correct.
And then they receive medical treatment.
One would hope so.
And in those cases don't really provide much guidance as to what happens when somebody has a much smaller amount, correct?
I can't answer that anything but yes, because you stipulated that they drank a big amount.
Is there some reason, if the answer that is called for is yes, that bothers you?
Just ask another question.
Well, I'm getting at bias.
Ask another question.
As I understand it, Dr. Mainland, you don't have studies that show how the person would go through the course of drinking 100 milliliters. True?
100 milliliters plus or minus 1? I can't recall one off the top of my head.
Plus or minus 25 milliliters.
There probably are. There's a lot of literature out there. I haven't read it all.
And you are aware of at least one case in which the person had ethylene glycol in their stomach 30 hours after consumption, true?
Yes.
You talked on direct examination about Librium.
I can't remember.
Okay.
Yeah, I think I did.
I think you indicated that one use for Librium is for anxiety. Is
I
that right?
remember that now. Yes, I did.
It's also used for other things, correct?
Yes, I'm not as familiar with those uses. I'm familiar with a couple of them.
It's used for esophageal spasms? Correct.
It can be.
That's one reason why it's prescribed, is for esophageal spasms?
I understand that's why it was prescribed in this case.
Is that a yes, that is one reason that it's prescribed?
Yes.
You at some point calculated how much ethylene glycol actually was in the stomach?
No, it wasn't. I didn't really calculate it. I mean, that's kind of, wait, all right. The question wasn't clear. Ask it again. You mean at the time of death?
Yes.
Yes.
You know that there were 2.6 grams in the stomach, true?
Yes.
Because you did that calculation by taking how much there was per milliliter and multiplying it by 660 milliliters, correct?
Correct.
That's a calculation that any pathologist or toxicologist can perform, correct?
One would hope so.
Can you tell me what the difference is between an amount and a concentration?
An amount is just a number, I guess. I don't know if I want to say out of context or not, but a concentration is how much of something there is in something.
Like a proportion?
It wouldn't, proportion would make it there'd be another step in that calculation. But yeah, how much of something there is in something.
Well, I'm sorry, I'm not sure.
A proportion, to me, a proportion is like, a fraction or something like that, but
Can you tell me what I don't understand, and maybe you could help me again, the difference between an amount and a concentration?
okay, amount is, an amount is a number. Like, I put 1 teaspoon of sugar in my coffee. That's an amount.
The amount is 1 teaspoon.
Correct.
What is a concentration?
It would be however many grams or whatever volume, weight or volume, however you want to use it, of sugar per unit volume of coffee. So, I mean, you could express it as grams per deciliter, milligrams per milliliter, milligrams per liter, ounces for ounces, depending on the units that you chose to express it.
Okay. When you got on this, well, that's not true. When you started this case, you understood that the defense had exposed the error that Dr. Long had made, correct?
I think I was told that I think, if I remember right, I was told that there was an error and it was discovered by the defense. I don't recall anybody saying who made the error.
Okay, and you subsequently came to learn that was Dr. Long?
I don't think I did. And, oh, sorry. I'm sure you'll get to it.
Just a couple questions about metabolism that I forgot. A fatty liver can slow metabolism?
Of what?
Would it slow the metabolism of ethylene glycol?
I'm not sure.
Does a fatty liver slow the metabolism of alcohols?
Oh, geez, I would have to look that up. I can't remember. I kind of don't think so.
Are you unsure, or are you saying that's not the case?
I'm saying that I would have to look it up and to give you a positive answer, but I don't think it necessarily does. It's the best I can do, sorry.
You'd agree in this case that based on Julie Jensen's distended stomach and the contents of her stomach, that her stomach may have stopped emptying?
That's one possibility.
And so that's true, her stomach may have stopped
It
emptying?
may have.
You testified yesterday on redirect examination about an episode that you understood occurred in November where Julie Jensen got sick at home
Yes,
and that she had thrown up, correct?
yes. I
And that
think
she-
we talked about that.
I beg your pardon?
I think we talked about that.
And that she had not cleaned up the vomit in the home?
I think we talked about that.
Now I'm just asking, do you recall this from your review of this case?
Yes, I do.
Did you understand from your review of the case that this incident happened while Mark was out of town for several days?
Yes.
From your review of the case, did you see any information where anybody reported that Julie Jensen had been sick for a several-day period of time prior to December 1998?
Reported to whom?
To anyone?
That was my next question.
In her whole file? All the witness reports she's read, police reports she's read, everything?
I think the source of the information on that was Mark Jensen.
You understand that, for instance, the Voights talked about having daily contacts with Mrs. Jensen, correct?
Yes,
And that she had contacts with other neighbors periodically, correct?
yes,
And that she had contacts on occasion with people at school, right?
yes.
Did any of these people report any recollection of her being sick for a several-day period of time in early November?
I don't think so. I don't remember reading that.
Did any of these people report that Julie Jensen was not tending to her usual activities for a period of time in early November?
I don't remember reading that.
Did any of these people indicate that Julie was requesting help in taking care of her children for some period of time in November when Mark was out of town?
I don't remember that either.
Yesterday, you surmised that perhaps that was an additional ethylene glycol poisoning, right?
Yes,
Which would make her sick for several days, right?
not necessarily.
So now you don't necessarily get sick for a few days from ethylene glycol?
No, I don't think I ever said that, that you had to. I think I said it depends on the dose.
And do you have any particular reason to think that it was ethylene glycol that made her sick in November, Dr. Mainland?
Yes.
And what is that?
Testimony in this case.
Well, other than her throwing up, well, and you would agree that people throw up from all sorts of illnesses, right?
Certainly.
And there was nothing particular about her vomiting in this case that made it sound like ethylene glycol, true?
I can't agree with that, no.
There was no claim that she appeared intoxicated in early November, right?
I did not see that in writing, or I didn't get that from any of the testimony in this case, or the witness interviews, no.
There's no interview, report, or anything else in this case showing that she showed any symptoms of ethylene glycol poisoning in early November?
Again, The source of the information was Mark Jensen.
Well, Mark Jensen wasn't even home at this period of time. That's your understanding, correct?
Correct.
And so you don't have, is the answer, you don't have any report, witness statement, anything attributing symptoms of ethylene glycol poisoning to Julie Jensen in early November when she got sick?
Not directly linking the symptoms. I have statements that this was an attempted poisoning, but I don't have reports linking the specific symptoms.
What you have is Aaron Dillard, right?
And Ed Klug, I think. I'm not, yeah.
Or can you identify any testimony or statement of Ed Klug where he said that that took place?
I thought he did, but if I might be wrong.
So what you're relying on is simply Aaron Dillard, right?
No.
What other evidence do you have that that was ethylene glycol poisoning in November other than just your general suspicion of everything on the defense side?
Objection to the question argumentative, Your Honor. And assumes the existence of fact not evidence to it that this witness is suspicious of anything on the defense side.
I'm sorry, I'm sorry, what?
Assumes the existence of fact not evidence to it that this witness suspects everything on the defense side.
I'll re-ask it. What evidence do you have besides Aaron Dillard that this is ethylene glycol poisoning in November, given that no one describes any symptoms associated with ethylene glycol at that time?
The totality of the case, all of the information that I reviewed and synthesized, I believe that it's a distinct possibility, if not a fact, that the incident in November was a poisoning. And I could go on and on, but I'll let you ask the questions.
Can you tell me a symptom she showed that makes you think that was ethylene glycol?
Vomiting.
Which could be attributed to thousands of things, right?
I don't know about thousands, but lots.
So, and she would have to have a pretty good amount to make her sick from the ethylene glycol, right?
No, not necessarily.
Might it also be a symptom of depression that somebody would get sick and not bother to clean it up?
I think you could probably call anything a symptom of depression if you wanted to, but I certainly wouldn't call that a common symptom of depression.
You could also call just about any kind of sickness ethylene glycol poisoning if you wanted to, couldn't you?
No.
Did she get any medical help that you're aware of in November?
No. Not that I'm aware of, I'm
You've
sorry.
looked at Dr. Borman's notes. There's no indication that she came in for any sickness in November, right?
I don't recall that she did, no.
Turning to suicide, you indicated that one reason for your belief that this was not a suicide was that there was no sort of suicidal testament. That be right?
Yes, that's one of the reasons.
You recognize that most people who commit suicide do not leave notes?
I guess, yes, that's true. The majority don't.
Most people who do commit suicide have seen a doctor within 3 months of their suicide?
I used to know the answer to that, but I don't remember it now. I did some research into suicide in the elderly, and I think that might be true in that population, but I'm not positive about the general population.
Is your recollection from that research you did that a substantial number of people, at the very least, do see a doctor shortly before they commit suicide?
Objection, Your Honor. The witness indicated it's irrelevant because the witness indicated that it was research into the elderly, and Ms. Jensen, by all accounts, was not an elderly person.
She did not say it was exclusively
But I
the
think you need to
elderly.
clarify what you mean by shortly. Otherwise, the question is meaningless.
And shortly, I said within 3 months.
What was the first part of the question?
From the research that you conducted into suicide, is your recollection that a substantial proportion of the people who commit suicide have seen a doctor within, say, 3 months of their commission of suicide?
I can only speak to the population that I researched. I looked at suicide in the elderly, and it is true that the majority of elderly that kill themselves have seen a doctor within 3 months. That's all I can speak to.
That's because you don't typically do extensive research in the field of suicide, right?
I'm too busy doing the cases.
Well, you're here testifying as an expert on redirect examination about suicide, doctor, right?
Yes,
And so is it reasonable to inquire about how much research you've done in that area?
yes it is, and I've answered your questions.
And as you just said, you're too busy doing your cases to do extensive research into the area of suicide, right?
I guess I'm going to make you define extensive research.
Well, you're too busy to do any research into whether people see a doctor immediately before, correct?
You know, these strike me as argumentative. She's made the statement as to what she's accomplished and or what she's done, and you're inquiring, kind of being combative with her. So just ask a question that's of value to the jury.
Dr. Mainland, you testified on redirect that the fact that she saw a doctor was one reason you considered that perhaps she was not suicidal.
I think, again, I'm not sure that was the context I answered it in. I think I said I wasn't sure why she went to the doctor. I can't remember what I said, honestly.
You recognize that many people who commit suicide struggle with that decision over long periods of time, correct?
Yes,
They change their mind frequently about whether they should or should not, correct?
I'm not so sure about that. I know people, certainly I've seen many cases where people have talked about it for years and years, or, had attempts over the years.
It's not at all unusual for people who commit suicide to have future plans made, correct?
I'm not so sure.
Well, why aren't you sure? Is it because you haven't done the research in that area?
It's because in order to answer that truthfully, I'd have to really go back and look at cases one by one. I guess, yeah, if you want to say I haven't done the research, I haven't done the research.
Well, again, you're here as an expert, and so I'm asking if you've done the research. And is the answer no, you haven't?
I haven't published anything or given any talks or made any presentations about whether or not people who commit suicide typically make plans for the future or don't.
Okay, but you understand, well, yesterday on direct examination, you suggested to this jury that the fact that she had some future plans was inconsistent with suicide.
And it is.
Well, you don't know whether the research supports that, correct?
I don't know if there's any research into that area.
You don't know one way or the other.
No, I'm just saying that that was one factor that is not consistent.
Well, you recognize, as we talked about with medical issues, that things that seem logical to a layperson aren't always the case with an expert who's researched the area, correct?
Correct.
Things are counterintuitive, correct?
Sometimes.
And the answer is you don't know whether this area has been researched?
I suspect it has. I'm not aware of the research in that area.
And so you're not in a position to give an expert opinion as to whether that's a factor that's relevant in terms of assessing suicide risk?
No, I don't think that's right. I think I am qualified to give an expert opinion about that.
Well, what research is that expert opinion based on?
It's not based on research. It's based on doing hundreds and hundreds of suicide cases.
Well, do you research the background of each and every one of those people?
Yes, pretty much. If it's available.
How many hours would you, if you have a hanging case, how many hours would you spend in researching that person's background to see if they had future plans or not?
I would get either I or my deputies would talk to family and friends and acquaintances, and if there were medical records, we'd get them. And I can't give you an hourly number because it's different in each case. Some people have reams and reams of medical records. Some people only have a couple pages. Some people have none.
Have you made an effort to take this data and develop any statistics so you can tell us what percentage of the people have future plans and what percentage do not?
No.
Do you know who the actor Owen Wilson is?
I've heard the name. I really don't. I don't know if he killed himself lately. I don't follow Hollywood. I'm sorry.
Okay. You recognize that it's unfortunately not infrequent that women with kids will kill themselves.
I don't know if I can answer that. What do you mean by not infrequent? Women with children have killed themselves.
That can happen without warning sometimes, correct?
Yes.
Did you have a chance to review Mr. DeFazio's notes?
Yes, I did.
Mr. DeFazio, when he treated Mrs. Jensen in 1990 and 1991, noted a seasonal depressive disorder. Is that right?
Yes.
A seasonal depressive disorder is a depression that tends to get worse as the amount of sunshine goes down. Is that?
That's the typical form of it. There's also an atypical form of it where the depression is worse when the amount of sunlight increases.
At the time he noted this seasonal disorder, it was in the fall, correct?
I can't remember when he diagnosed that. All I remember is seeing it on the paper.
And do you have his notes with you?
No, Ms. Gabrielle does, I believe. Or Mr. Jamboys? Or
I don't.
did you guys give him to me?
DeFazio notes, yeah. Doctor, I'm going to show you Defendant's Exhibit 222. Are those the notes of Dr. DeFazio, or Mr. DeFazio that you reviewed?
Yes.
I'd invite your attention to the note for October 8th, 1990.
October 8, I see it.
There's an indication that there's an increase in depressive feelings in the fall.
I'm sorry, Counsel, what page are you on?
It's October 8th, the note.
October 8th?
I don't
Thank
think
you.
there's page numbers.
Thank you.
Is that right?
Yeah, I just found it.
So her seasonal depression did not appear to be atypical, correct?
If you take this description, no.
Well, and if you look at September 4th, she first mentions her seasonal depression, correct?
Sorry, I didn't memorize these. The doctor notes it. I don't know. I guess I would presume that he diagnosed it then.
You say the doctor, it's Mr. DeFazio? He's not a physician or
Or I'm
psychologist, is he?
I don't know, Mr. DeFazio. I don't know what his title is.
Psychotherapist.
Okay. It's noted by the psychotherapist. I don't know if that was words out of her mouth or if that was his diagnosis, but it is noted in the record.
There's an indication in those notes that Julie Jensen reported chronically depressed, cry easily. That's in the October 8th note.
I think I saw that. Okay, point me to the part of the page it's on. Let's see. Keeps problems inside.
Oh, and I apologize. It's on that last page.
Oh, okay. Oh,
And it's at the second from the bottom.
chronically depressed, cry easily.
And going back to the other page that you were on from the October 8th. She reported, in addition to the increase in depressed feelings in the fall, there's a decrease in appetite, correct?
Yes.
There's an indication at the last note for October 8th, 1990, that she reported she keeps her problems inside, mulling, ruminating,
Yes.
can't seem to push them away.
Yes.
That was noted in October of 1990 regarding her situation, correct?
Yes.
That prior depression would be something that ought to be considered in evaluating suicide risk, correct?
Certainly.
The records also reflect that she was, in fact, prescribed Prozac and taking it at that time. True? I think that's the very first page.
Says she was given samples of Prozac.
Presumably, those samples are given for her consumption. True?
Presumably.
And that's an antidepressant.
Yes, it is.
May I approach, Judge?
Yes, sir. All right, the record will reflect that the sidebar was about, Mr. Albee approached and he said he wanted to go into some content from Mr. Jensen's statement. I kind of cut him off and told him I had been rethinking this since we discussed it an hour ago. And it had been discussed yesterday in terms of the doctrine of completeness. And I don't have any problem with the ruling that I made and the reasons that I gave on that, but I rethought it under the rule that an expert witness who bases her opinion on certain information is subject to cross-examination concerning the information upon which she has relied, and she's reported that she's relied this and she's relied upon this transcript of a statement attributed to the defendant. And for that reason, I think that the whole thing is subject to inquiry and presentation by the defendant. Now, you indicate that you have some disagreement with that?
Well, I don't know that I disagree with what you just said, but I disagree with what we said at the sidebar, because my understanding was that what you were saying at the sidebar is the whole thing comes in. And the entire transcript or the entire videotape of the interview of Mark Jensen comes in, is admissible because this witness has read the transcript.
Not just read it, has relied upon it, informing her opinions, and the answer is, then you understood me properly at the sidebar.
Yes, and that's the part that I object to.
Yeah, go ahead.
And I don't think the fact, Your Honor, that
And I might say that these sidebars are really discouraged in Wisconsin. They may be commonplace elsewhere and used for purposes of having discussions about very important and explosive matters. I have been scolded myself, and other judges have been reversed. I didn't get reversed, but I certainly got scolded about having a sidebar and discussing things of value. So I just want to tell you that the sidebars are for cases when someone has to go to the bathroom.
Judge, let me just explain that. I was about to...
I'm not criticizing you. Don't misunderstand. I just want to...
I know. I mean, but just in terms of for the future, because I think even I bet you Mr. Jambo is going to be in agreement with me for once too. Is I was about to walk up there. I was going to put that down. He was going to say, absolutely not. It was, and it was going to be something that we were probably going to discuss outside, and I just thought we'd get it over with without having to blow up.
And if we had the whole thing to do over again, I would agree with you. But I think that the wise suggestion was Mr. Jamboy said he wanted to make a record, which is why exactly these sidebars are discouraged. But they may be common practice elsewhere, but they are not in this state. And where they are, the judges are running a high risk because there's no record being made. But anyway, I cut you off.
I don't have a problem with how any one of the three of us handled the sidebar issue, and I object to the court's apparent conclusion that because this expert witness, she looked at a wide variety of hearsay documents in coming to her conclusion, and then all of the hearsay documents that she looked at comes into evidence. For example, one of the hearsay documents she looked at is the transcript of the telephone call between Paul Griffin and the defendant, Mark Jensen, that occurred on, I think, January 8th of 2000. And there's been a motion to exclude that because they're alleging that it was obtained in violation of the wiretap statute. And so I guess under this theory, if she relied on that hearsay, it still comes in. And I guess so I'll be making a motion to admit the transcript of the telephone conversation, or at least that portion of the telephone conversation between Mark Jensen and Paul Griffin. And by the way, if we just exclude the wiretap statute, any portion of that transcript that I want to introduce, if it's relevant, it comes in as a statement by a party opponent. But the fact that she relies on hearsay doesn't mean the hearsay becomes admissible. What it means is that she can be cross-examined.
Well, as I look at the rule, I think you're right.
So now you've gone back the other way again. And
well, that's why we have these discussions.
And I agree. That's a perfectly sound reason to have that discussion. That's why I wanted to have it.
Ruled in your favor.
And I agree with you every time you do that. But so let me just say this about the basis for an expert witness's testimony, and then I'll be done and allow Mr. Albee to respond. The expert witness's testimony is admissible insofar as this is something that they would normally rely upon in coming to their conclusion. There's been no testimony from this witness about the extent to which she would rely upon Mark Jensen's misrepresentations or his statements. I think that, and I don't want to influence the witness, so maybe I should ask the witness to leave the room so that she doesn't hear what I'm about to say.
If you want to, that's fine.
I'd ask the witness to leave the room.
Step outside, doctor. Sure. You don't want to be in with all these lawyers anyway.
Because again, I'm sensitive now to this speaking objection concept. So, thank you, doctor. Now,
I believe that if the doctor is examined on the issue of Mark Jensen's statements, she's going to indicate very likely that she believes them insofar as they are supported by the history, and if he was not able to determine at the time he was making the statement whether it would make him look guilty or innocent. So when he is describing to Paul Griffin, for example, Julie Jensen's condition from Tuesday night through the time of her death, and he does that. At that time, there was no reason for us to believe that Mark Jensen would have been able to assess the implications of telling the truth. However, when it comes to this issue of suicidal ideation, there's clear evidence in the record that Mark Jensen was trying to get his fellow coworkers, especially Dave Nearing, to believe that Julie was suicidal, and to the point where David Nearing was concerned about it and had his wife actually go do a reality check by taking Julie out to lunch. And what they found was that Mark Jensen's representations concerning Julie were not borne out by their independent observations. So there was a clear effort on the part of Mark Jensen to make it look like his wife was suicidal in the weeks preceding her death. And that coincides with his efforts on the internet to look up ways to kill her. And that's what I believe this witness would say. Not that she read this transcript and concluded, oh, well, Julie Jensen was suicidal because Mark Jensen says so. Mark Jensen was saying she was suicidal because that fits into his plan to murder his wife and make it look like a suicide. That's what I think this witness would say. And that doesn't make all of the defendant's self-serving statements independently admissible. And I believe that if the defendant wants to get on the witness stand and testify about his wife being suicidal, that's fine. But then I get to cross-examine him. And we don't get his statements in through the back door in this manner, which is what defense counsel would like to do because, frankly, from a strategic perspective, the more of this statement that comes in, the less likely it is the defendant is going to take the witness stand.
Well, look, let me ask Mr. Albee to respond.
Judge, the rule in terms of disclosing the data underlying the expert opinion is 90705, and that rule provides, in part, the last sentence of that rule is the expert may in any event be required to disclose the underlying facts or data on cross-examination. And starting with the issue that I approached the court at sidebar, what I intend to do is, because this witness considered Mr. Jensen's statements to Detective Ratsberg, is point out those parts in which he explained her history of depression, which this expert said she would consider. She ultimately says she rejects, but it's part of everything that she considers. It's part of the data she considers. And I don't think she can just talk to the jury about what she accepts. She has to talk about all the things she considered. And she can be required to disclose those underlying facts or data on cross-examination. So that's one part of things. We've now gotten into the completeness issue, and Mr. Jamboys talks about things like Dave Nearing's statements, and I imagine he'll bring in some other select statements during his examination of Detective Ratsberg. And we've had some statements that Dr. Mainland's relied upon from Paul Griffin. And the doctrine of completeness doesn't require, it's not restricted to just the particular statement introduced. That is, if Mr. Jamboys wanted to introduce pages 1 through 100 of the transcript, I can ask that the rest of it be, I could say that in fairness, the rest of it may be considered, but also I may say in a particular case or in response to some particular evidence, I may say that transcript has to be considered in order to put some statement after the recorded statement into context, because the jury should know what happened during that trial, during that interrogation. He talks about, for example, Dave Nearing and what Dave Nearing had to say, and we get sort of Dave Nearing's biased perception of what Mr. Jensen had to say, and I think in doctrine of completeness is what was taken down at the time by the police officers. I also, frankly, I think in addition to the doctrine of completeness under 90806, these are hearsay statements of Mr. Jensen's that are being introduced, and I may introduce testimony that's inconsistent, or statements that are inconsistent with with those statements?
I don't want to
Edmund?
get too much into the discussion about the doctrine of completeness because I've already decided that. And that was that you needed to specify what specific areas you wanted to consider and why. Now, we're on the separate issue, and I do think your point is a legitimate one, that not just what doctor has considered, but that which she has discarded after giving it a consideration are legitimate areas of inquiry. If she were asked, for example, why, whether someone had a heart attack or not, and she decided to accept a statement of the individual about having suffered chest pains and having difficulty breathing, but discarded a reference that he made to sweating profusely, it would be fair a cross-examination for the defense to ask, well, what about this? So I do think that statements which otherwise would be hearsay statements from the accused, if considered by the doctor, whether accepted or rejected, can be inquired into on the cross-examination. But I do agree that the rule is not as sweeping as I was thinking about before I looked at it, and would not justify full receipt of the entire statement.
Your Honor, may I be heard in this one thing? I was just reading the Wisconsin Practice, Wisconsin Evidence by Professor Blinka, who, as you know, is a professor at one of the two very best law schools in the state of Wisconsin.
Well, I think you're cutting your number way too short.
And he writes on page 509, the danger in permitting inadmissible, he's citing a court. The court explained the underlying rationale. The danger in permitting inadmissible hearsay to serve as the basis for expert opinions is that hearsay may reach the trier of fact through, quote, the back door, unquote, of cross-examination if experts are asked to explain the bases for their opinions. Then he cites to an amended federal rule of evidence, and in footnote 36, and it's amended FRE 703. And he writes, in particular, the last sentence states, quote, facts or data that are otherwise inadmissible shall not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative values in assisting the jury to evaluate the expert's opinion substantially outweigh their prejudicial effect. Now,
I agree with Professor Blinka.
And so at least my purpose in citing that was to go to a higher authority than myself in explaining the limitation that should be imposed upon Mr. Albee in cross-examining this witness concerning the bases of her opinion insofar as she relies upon otherwise inadmissible hearsay. And this is inadmissible hearsay that is prejudicial because it is the defendant's own self-serving words, which would not otherwise come to the jury unless the defendant were uttering them himself in front of the jury and subject to cross-examination on that point. So the state is very unfairly prejudiced by allowing Mr. Albee to get in through the back door of cross-examination of this expert all of the defendant's self-serving rationale, his self-serving statements concerning Julie Jensen's condition. We've already introduced to the jury some evidence of Mr. Jensen's self-serving remarks, but we did so through Mr. Nearing, and we did so through the purpose of showing to the jury that he was lying. And I think that's the circumstance on which the state can get it in through hearsay, because then it's not hearsay, it's a statement by a party opponent. When we're offering it, it's a statement by a party opponent. When Mr. Albee is offering it, it's hearsay. And he should be significantly restricted on his cross-examination of this witness with regard to the otherwise inadmissible hearsay. And Mr. Albee is free to borrow our book on Mr. because he came over here to take it, but there's an implied consent. He can use it whenever he wants.
Well, it looks from Judge Fine's comments that the evidence should be received with a cautionary instruction or a limiting instruction.
And is he talking about the defendant's own statements?
Well, why don't you take a look at it? I definitely need to take a break.
Okay.
Okay.
And we'll be back in a couple of minutes.
Okay.
Let's take our break now. You can have a break until 25 minutes too, and then we'll continue the discussion.
Thank you, Judge.
Prestigious. Marquette University Law School. Which is very helpful, but he makes the decision have even more Byzantine features that we have to work through. And it also strikes me now, Mr. Albee had an extra, had come up to me and handed me the book and asked me if I wanted to read it, which told me that he thinks there's something of value in there. So now I have both lawyers citing the same authority for contradictory positions. So that's going to make my job really easy. But
If you graduate from Marquette, you no doubt think a lot more like Mr. Blinka than I do, so.
well, anyway, the bottom line is this: well, why don't I hear from you first, and then I'll try to decide what to do. Go ahead.
Okay. Well, again, the witness is here, Your Honor. I don't want to be seen to be coaching.
Can you step
witness,
out,
so
Doctor? You can have your choice of the media types out in the hallway or the lawyers in here. I know which I'd pick.
I need my exercise.
Okay.
This will be about 5 minutes. And you can even tell by that exchange, she knows who to believe in that too. But I think the first question that if counsel intends to seek to introduce any significant number of these or any portion of these self-serving statements by Mark Jensen through this witness, I think the first thing he has to do is ask her whether she believed Mark Jensen's description of Julie Jensen. And if she says yes, then ask what things she relied upon. If she says no, then what difference does it make what Mark Jensen said? If she believed that Mark Jensen was describing Julie Jensen's suicidal ideation, but he was not truthfully describing it, he was doing that in order to further his theory of how he was going to commit this murder and make it look like suicide, then she didn't rely upon it to form her opinions about this case, other than to say, okay, Mark Jensen was saying these things about Julie Jensen, but it was apparent to me that he was saying these things about Julie Jensen in order to support his manner of committing murder.
Mr. Albee?
I believe she's already indicated that, of course, she considered Mr. Jensen's statements along with everything else, and she's relying on Mr. Jensen's statements as to certain things. I think Blinka's treatise reflects appropriately that the rule also can encompass cross-examination about things the expert should have considered, and that the jury, in order to properly evaluate the expert's testimony and opinions, must consider the reasonableness of what she accepted and what she didn't accept. I also think it's dangerous territory and should not be gone into at length in terms of, do you believe him? Do you believe her? Do you believe, I mean, obviously she's doing that to some extent, but I think direct questions on those kind of matters would be inappropriate. You know, I mean, for her to say, oh, I don't believe Mark Jensen, he's a liar, I don't believe him, whatever she wants to say. I mean, I think that could, but the fact is she considered his statements. She's already indicated that. She's considered this whole interview. If she didn't, she certainly should have. You can't, just because you're the medical examiner employed by the prosecution, you can't go into a case saying, well, I'll only consider what's favorable to me. I mean, she certainly would have to consider whether this is an alternative hypothesis that should be given some weight. The Blinka book and the rule makes clear it's not a hearsay exception that allows the proponent to say, well, tell me what you relied upon. Tell me what it says in there. And the court will notice I haven't asked any questions about Paula Griffin. I'm not touching that. I'm not opening that to let her read in any of that stuff, because it's not a hearsay exception that allows that in. On the other hand, it's clear that the expert may in any event be required to disclose the underlying facts or data on cross-examination. And this is something that not only has she considered, but it's something that typically an expert would consider. And she said that in the beginning as to who she would, in making her, giving her opinions in an autopsy, she considers interviews with friends, family, people close to them, certainly in evaluating suicide, the person who lives with the individual is going to be an important source of information. So it's obvious she's rejected it out of hand. The question is, it's here, and she needs, the jury has to evaluate whether it's reasonable for her to reject that information that she had.
Well, but I think Mr. Jamboy's point is a good one, is that if she says, I don't believe him, when you say, I don't believe him, you've said it all. And then it's a matter of argument for you. Well, Dr. Mainland's opinion is worthless because she prejudged the case by deciding that Mr. Jensen's lying about what happened, and so you should discredit her report in its entirety, and that would be a very valuable victory for you if you could persuade the jurors to do that.
They need to know what it is that she rejected in order to make that evaluation, that she should have considered it. And that's why the statute allows to the requirement of disclosing the underlying facts or data on cross-examination.
Well, that's where the balancing comes in. And if she discounts everything that he said that's self-serving, I have to balance that. Pardon me?
I mean, going back to Lenarchek, and I know it's in a different context, but there used to be a rule that the defendant couldn't present he couldn't testify, he couldn't present his self-serving testimony to explain even what happened during police interviews. And in Lenarchek in the mid-70s, they said, no, you can't do that. I mean, we can't be hamstrung more than the state. The state got an inadmissible by law testimony, essentially backdoor, of Paul Griffin by saying, did you rely on Paul Griffin, and what information did you get?
I don't agree with your
It is. She relied on transcripts of it.
Oh, I'm sorry. I misunderstood which reference you were making.
Yeah. And that's the problem.
That's what she relied on, though. That's what she relied on. And I understand that there are circumstances in which, you could impeach the doctor by saying, doctor, you didn't rely on this. Like when you were asking her about creatinine levels and that type of thing, that you were trying to suggest that she had not relied upon important information, that it had a negative effect on the value of her opinion. But here, she's being very upfront, I assume. She's going to say, well, I didn't, if she hasn't already so much as said it, I didn't believe what he had to say, so I discounted it. And the bottom line is, we're not going to let her supplant the jury in making a credibility determination, but we have allowed her to give her expert opinion, and now she has been asked to justify it. And if she wants to justify it by saying, yeah, I didn't consider any of that, I agree with you if there were something that was evident, I'm going to say this, I'll probably be wrong, evidentially neutral, then you'd be allowed to ask about it. But I have to, as Professor Blinka has stated, I have to do a balancing test about the fact that you're bringing in evidence which is not permissible. And the Jensen thing is not the statements of Paul Jensen are not the same, because she stated, Paul Griffin are not the same, because she stated, I did rely on them.
But you're saying this is for the jury determination? They can't, we are substituting her version, her weighing of the facts for the jury's, because she's the only one that has all the facts in front of her.
And if she...
And she, one of the important things that she said, and again, I think I would move to strike all of her expert testimony on suicide, given her limitations, but one of the things that she said she relied on is that there weren't any statements of suicidal intent by Julie Jensen. Well, Mark Jensen says there are, and she had that information, and she reviewed it, and she considered it. And that's something the jury can say, well, maybe I shouldn't credit her opinion that there's no statements of suicidal intent, because you could accept that.
May I be heard, Your Honor? I agree that this witness can be asked. Well, you said that there were no statements by Julie Jensen of suicidal intent, and yet there are statements where Mark Jensen is quoted as saying that Julie made some statements of suicidal intent. And then she could reply, yeah, but I didn't believe him. Because Mark Jensen is the only source of that information, and it's consistent with
Well,
this
you don't
theory
need
of
to,
murder.
let's not get too far into what she's going to say. But
Well, I don't know what she's going to say. But
I
if she was-
understand, but she could say, I simply didn't believe him. And, you run a risk there that the jury will embrace her analysis of it.
I don't think this allows her to be super juror and give her beliefs, and she's done this over and over again. I think she can say what she considered, and she can give her medical conclusions about this, and in terms of that, deciding the credibility of that.
But her medical conclusion is that it was a homicide.
Right, and she's already said that. So,
And you're trying to undermine it and she's defending it. So, of course she's saying things we wouldn't typically allow a witness to say, but she's an expert witness, and I don't think that on the direct examination that she went into nearly what she's going to on the cross, and you've been at it for 3 days, and don't misunderstand, that's your decision, you're handling your examination, but you're the one who's prying out these answers.
well, but she did say she relied on the absence of any statements of suicidal intent. And
Well, I think that I think probably that. I guess we'll have to go by specific area of inquiry, and the suicidal intent is one that I would allow, and, you're going to have to
here's my suggestion.
you're going to have to deal with what may be a very explosive answer, and
That would violate Hazelton, I think, to say she's believing one witness or not. I think she just ultimately says, I considered that and I rejected it. I don't think she gets to go on and on and the credibility.
well, if you ask her why she didn't value a statement of that enormity that Mark Jensen says that Julie Jensen has committed, has made prior suicide attempts, you can't shackle her to just saying, I considered that and rejected it. She has a right, and the prosecution has a right to bring out why she rejected it. And if she says, because I think he's lying, you've got to understand that that's what's going to happen, and you run a risk, and I'm sure, you know very well what the risks are, that the jury may embrace that.
I don't think that's an appropriate statement for an expert to give.
She's got to give the reason why she discounts something. She just say, I rejected it out of hand.
What I would intend to do is say, you said that you testified on direct that there were no statements of suicidal intent. However, you did have them in this interview with Detective Ratsberg. I would read from line 24, page 172, through the bottom of page 170, through the bottom of page 176. I would say, and you had those contrary statements of indicating that Julie Jensen had made statements of suicidal intent.
And I would object to that.
I'm not going to have you read the extensive examination during the interrogation. You can ask generally about whether or not the defendant recounted specific efforts by the decedent to commit suicide.
I'm sorry.
You can inquire of the doctor, isn't it true that in Mark Jensen's statement, he recounted prior suicide attempts or efforts by Mrs. Jensen? And then you can ask her if she rejected them, and if so, why? Or if you don't ask if so, why she rejected them, then I assume the prosecution is going to clean it up.
She has indicated that she considered this interview, Exhibit 142, and I think reading 172 through 176 would be appropriate in terms of establishing what contrary information she had. This is the specific information that she did have, as opposed to trying to characterize it. She had this specific information, And so I think it would be appropriate to provide it to her, and that's my specific request, is to be able to read that. I do not think that I can make a proper showing without listing the specifics that she had available to
And
her.
I don't agree with you. I'm not saying that if the evidence developed in a different way, and she said she gave some other reason why she discounted or something, that we wouldn't ultimately get there. But I think that allowing the particular passage that you want to read which is ordinarily not admissible as hearsay, would be very prejudicial to the state, and I'm not going to permit it. But you can summarize what, no, you can ask what I've indicated, that whether or not.
I'm clear on that, Judge. That's why.
You can inquire whether she was aware that the accused had made statements suggestive of a desire on her part to commit suicide and had made efforts in that direction, and whether she had relied upon that information and cover and run for cover.
My last statement on that is this restriction carries all the negatives and none of the positives for me. And of course, I won't go into it. Whereas the specific things that she had and relied upon developed for the jury why this matter was worthy of greater consideration by her than she was willing to give it. And I can't do that by just asking a solitary question. That would be poor cross-examination practice. I think I would fail to make any kind of a convincing case on that. And as the court has forewarned me, I'll be slammed by it because there's no limitations on their asking Hazelton-type opinions about what witnesses should be believed in that.
Well, Your Honor, look, first of all, I think that's not a fair characterization of the court's ruling, and so let me make a record on this. The defense attorney wants to cross-examine the medical examiner about an interview that occurred between an accused murderer and a police officer investigating a murder. And if he wants to do that and suggest that she's supposed to attach some significance to what the accused murderer has to say, there should be a full expectation that on the redirect examination, or in this case, a redirect examination, the prosecution is going to go through that interview and pick out such things as, well, if you were to believe everything he said, well then Mark Jensen really didn't have a motive to murder Julie because he wasn't having a romantic relationship with Kelly Labonte in the weeks and months preceding Julie Jensen's death. But we know for a fact that he was, because she said he was, although she initially lied about that too. At some point, you have to break down the lies of a murderer, and that's what is going to happen on the redirect examination of this witness. Now, it's not, I think the court has been very good to the defense counsel to warn him of the implications of the path he's going down. Because clearly, that's something I'm going to go into on the redirect examination. Of all of the reasons to believe that Mark Jensen, in addition to being a murderer and an adulterer, is a liar. And there's good reason for any reasonable person, including Detective Ratsburg, including this medical examiner, including me, to consider Mark Jensen to not be telling the truth. Just like a lot of murderers don't tell the truth when they're being examined by a police officer concerning the circumstances surrounding the homicide. So we should fully expect that that's going to be something that's going to be inquired into, either on on a redirect examination this witness has gone into, or, for example, on the cross-examination of the defense expert who is going to be testifying that Julie Jensen was suicidal.
Did you want to say anything else?
No.
All right. As I say, I think I've indicated what generally you can discuss and or inquire of the witness, and we'll leave it at that. Ready to go? Ask Dr. Mainland to come in, and also the jury.